Hi guys, and welcome to Law JTLG's YouTube channel. I'm Alan Lenczycki, a lawyer in Libertyville, Illinois, and I'm your dry erase attorney. I want to talk today about DUIs. So in the state of Illinois, DUIs are serious. They've been declining overall as the years have gone on because of people's better education about the risks associated with DUI, but it happens. And DUI is one of those cases that can happen to a lot of good people. You don't necessarily have to have a criminal mindset or be a bad person, like if you're making a choice about being a thief or hurting somebody. You don't have to necessarily have criminal intent, but you do have to make a choice to drink and drive. And Illinois DUIs are really serious. They're not the end of the world though if you're a first-time offender, and sometimes if you're a second-time offender, but they are quite serious. And I want to talk about DUIs just kind of in a general basis, and we'll have other videos delving into some of the specifics and some of the details. Anyway, let's get right into it. So you've been pulled over for a DUI. You're driving home from a party, you're speeding, police officer in a village in Lake County, Illinois pulls you over and wants to do field sobriety testing. The police officer usually begins that with learning about seeing some sort of traffic violation. That's what the initial contact phase of the case begins. But ultimately, if you're arrested having done field sobriety tests or refusing to do field sobriety tests, you're going to be charged by way of a ticket. And that ticket charges you with a Class A misdemeanor, okay? A Class A misdemeanor, as I've said in other videos, is a max penalty of 1 year in jail and a fine of $2,500 or both. That's the maximum penalty. So if you walk into court and say, "Judge, I'm guilty, I'm not sorry, do your worst," the judge could put you in jail for a year. You'd get day for day good time credit, so really get out in 6 months, but you're not going to do that, okay? And for the reality is that for most people with a first-time DUI, they're eligible for a really great program that Illinois has called supervision. I've talked about supervision in another video too, but let's go over some of the basics. Supervision is a way to avoid a conviction. So if you get supervision on a DUI case for one's first time, it's not a conviction on your record. And the benefit there is that you can tell an employer when they ask on a job application, "You ever been convicted of a crime?" You tell them the truth. "No, because I had supervision on a DUI case back in 2022. But you don't add that second part, you just say no. And that's telling the truth to a job employer. One thing it also does is it prevents your license from being revoked. We're going to talk about some of the consequences on your license, but there's two things that basically occur when you get a DUI. There is a civil case, and we call this a statutory summary suspension. It's the Secretary of State of Illinois suspending one's driver's license. That is because when you apply for your driver's license and you're a 16-year-old kid, you promise Jesse White, or whoever the Secretary of State is now in Illinois because I know he's retiring, you promise the Secretary of State that you're going to obey the laws, that you're not going to drive with a blood alcohol concentration over 0.08, and you're promising that you will provide a breath sample or a urine sample or whatever the police require if they request it of you. So if you don't do those things, you get your license suspended in a statutory summary suspension. So when you get a DUI, two things happen. That's civil prosecution, and the second thing is a criminal prosecution. They usually happen in the same courtroom. They're the same exact, well, not same exact thing, but they could be handled by the same judge, the same prosecuting attorneys, but not necessarily the same defense attorneys, okay? When you are a person that's struggling with money, if you're having a hard time making ends meet and you're indigent, you might qualify for a public defender. If you're doing a little bit better, you would want to hire a private attorney probably. Attorney's fees can be $2,000 to $5,000 for a first-time DUI, usually in this market area in Lake County, Illinois. But if you don't have that, you'd ask the judge, "Hey judge, please appoint a public defender in my case," okay? Now the difference between a private attorney and a public defender is the public defender can't work on your statutory summary suspension. So a public defender cannot do that, okay? They can't help you with that because it's a civil case. You're only eligible for a public defender under the Constitution, which gives you a right to have an attorney in your defense for a criminal case. With the civil thing that's happening to you, the suspension of your license, no public defender allowed. You've got to either do it yourself somehow, which people generally don't know how to do, or bring on private counsel. The criminal case here is a misdemeanor, okay? It's a misdemeanor. It's charged as a Class A for your first-time offense. If you were to ever get a second DUI a few years later, that's also a misdemeanor, but you're not eligible for court supervision. We'll talk in the next video about some ideas to defend a case from the statutory summary suspension perspective and from the criminal perspective too. Thanks for watching.